She is going to make some remarks, or Mr. Stewart. We also have with us today 3 witnesses from West Memphis, Tennessee, and they are here with their lawyer, Sean Williams, and we are also going to ask Mr. Williams to address you as well. So we have decided to issue warrants in this case today. I have with me copies of the warrants, and after my presentation, we will let you know how you can get copies of the warrants today. So the question is asked, why were we able to charge this case now? So I want to explain that we have already had an opportunity to speak with 3 of the witnesses in this case, and those are the 3 witnesses who were from West Memphis, Tennessee. We have had an opportunity to conduct interviews with 7 other witnesses other than the 3 witnesses from Tennessee. We've also had an opportunity to view, let's see if you can turn it on. Guess I just assumed. There you go. So, Tracy, that's fine, brother. So we have had an opportunity to review 8 videotapes, 2 Atlanta body cam tapes, 2 Atlanta Police Department dash cam tapes. We have also had an opportunity to review a Wendy's surveillance tape. We have also viewed 3 citizen cell phone videos. With many of the videos, we had the opportunity to enhance the videos so that we could get a better look. The other thing that we have had an opportunity to do is to view some of the physical evidence. The Chevrolet Trailblazer was a vehicle that was in the line at Wendy's on the night of this incident, and it received a shot from Officer Roth's gun. We've had an opportunity, along with the GBI now, to view that Trailblazer. My office has had an opportunity to inspect the crime scene. We have conducted a canvass of the area. We started our investigation at about 1:15 a.m. on Saturday morning, and we have been working on this case around the clock since that time. Go to the next slide. We have spent some time examining the Taser evidence in this case. We've actually examined and possessed the 2 Tasers that were used. We have also had an opportunity to examine the Taser logs that are prepared as the Tasers are used. And we have also consulted with a Taser expert from the company that manufactures the Tasers. We received a preliminary medical autopsy. We've received the preliminary ballistics report, and in reaching our conclusions today, we have worked with both the Georgia Bureau of Investigation as well as the Atlanta Police Department. This will be the 4th time that we have asked that arrest warrants are issued in a case before an indictment. This lists the other 3 cases that we were involved with where an arrest warrant was issued prior to indictment. Unfortunately, this marks the 40th prosecution of police officers for misconduct here in our county, and this is the 9th time that we've prosecuted a homicide case committed by a police officer. 8 of those cases involved black males, and 1 of those cases involved a black female. So in reaching our decision, there were some considerations that we considered important. And one of the things that we noted from our evaluation was that Mr. Brooks, on the night of this incident, was calm, he was cordial, and really displayed a cooperative nature. Secondly, even though Mr. Brooks was slightly impaired, his demeanor during this incident was almost jovial. Also, we noted that he received many instructions from the Atlanta officers, and he was asked many questions. Some of the questions he was asked repeatedly, but for 41 minutes and 17 seconds, he followed every instruction, he answered the questions. The fourth thing we noted is that Mr. Brooks was never informed that he was under arrest for driving under the influence. And this is a requirement of the Atlanta Police Department when one is charged with a DUI. The Atlanta Police Department's own procedures require that that person is informed immediately that they are under arrest. And then he was grabbed from the rear by Officer Roth, who made an attempt to physically restrain him after the 41-minute and 17-second discussion. We concluded and considered it as one of our important considerations that Mr. Brooks never presented himself as a threat. At the very beginning, he was peacefully sleeping in his car. After he was awakened by the officer, he was cooperative, and he was directed to move his car to another location. He calmly moved his car. Mr. Brooks was asked whether or not he had a weapon. He indicated that he did not. Without any resistance, he passed his driver's license to the officers, and the officers then asked Mr. Brooks whether or not he would consent to a pat-down or a body search, and Mr. Brooks allowed them to search him, and the search yielded no weapon. We found that it was of interest that when the officers patted Mr. Brooks down, they noticed there was a bulge in his pants. They did not pull that item out of his pocket. They took Mr. Brooks's word that that bulge represented a number of dollar bills. But Mr. Brooks never displayed any aggressive behavior during the 41 minutes and 17 seconds. Now, this is another important consideration that we discovered as we evaluated this case. Once Mr. Brooks was shot, there is an Atlanta policy that requires that the officers have to provide timely medical attention to Mr. Brooks or to anyone who is injured. But after Mr. Brooks was shot, for some period of 2 minutes and 12 seconds, there was no medical attention applied to Mr. Brooks. But when we examined the videotape and in our discussions with witnesses, what we discovered is during the 2 minutes and 12 seconds that Officer Roth actually kicked Mr. Brooks while he laid on the ground, while he was there fighting for his life. Secondly, from the videotape, we were able to see that the other officer, Officer Brosnan, actually stood on Mr. Brooks's shoulders while he was there struggling for his life. We were able to conclude that based on the way that these officers conducted themselves while Mr. Brooks was lying there, that the demeanor of the officers immediately after the shooting did not reflect any fear or danger of Mr. Brooks, but their actions really reflected other kinds of emotions. So as we are drawing our legal conclusion in this case, we were led by the two foundational cases in this matter, one being Tennessee versus Garner. And what that case points out is when an officer is pursuing a fleeing suspect, that the officer may not use deadly force to prevent escape unless the officer has probable cause to believe that the suspect poses an immediate threat of death or of serious physical injury to that officer. The next foundational case that we used in our analysis is Graham versus Connor, which says that this test is based upon that of a reasonable officer on the scene and not the individual officer, but a reasonable officer on the scene. We've concluded at the time Mr. Brooks was shot that he did not pose an immediate threat of death or serious physical injury to the officer or officers. If you would get the photograph, the taser. This is the first photograph that we were able to clean this kind of crooked to see if you can get a straight one. What this photograph illustrates is the point that Officer Roth at this point was firing a taser, and this is Mr. Brooks, who was firing a taser as well, but I don't know if you can see it clearly. The prongs from the table, the taser, were actually fired above Officer Roth's head. I'd like you to also look at the position of Officer Roth and Mr. Brooks, that they are here next to this red automobile. If we look at the next photograph, if we look at the next photograph, we'll see that the positions of both parties, they've changed. Mr. Brooks has now moved away from his original position, and we estimate the distance is probably about 12 feet. And Officer Roth has moved about 10 feet from the position in what is our exhibit number 1. This second video or second still shows the very instance that the shot was fired into the back of Mr. Brooks. And we have also calculated the distance, and the distance that they are apart at that time was 18 feet 3 inches at the time that this shot was fired. So based upon that information, we have concluded that Mr. Brooks was running away at the time that the shot was fired. Mr. Brooks was shot twice in the back. One of the shots was a center shot to the back that penetrated his heart, and it was done by a 9mm Glock. Now, one of the things that we also relied upon in our conclusion is something that is called under the law, referred to as an excited utterance. And that's when someone makes an immediate statement, and because it is made without the ability to consult with counsel or to think about it, under the law, an excited utterance is considered as highly reliable. And at the time that the shot was fired, the utterance made by Officer Roth was, "I got him." That was the statement that was made at that time. We also noted that Officer Roth was firing a taser at Mr. Brooks. The City of Atlanta SOPs, in fact, prohibit officers from firing tasers at someone who is running away. So the City of Atlanta says you cannot even fire a taser at someone who's running away, so you certainly can't fire a gun, a handgun, at someone who is running away. So in addition to our findings, as many of you all already know, that the Atlanta mayor, Mayor Keisha Bottoms, and the police department concluded that Officer Roth's actions were excessive and in violation of APD's SOP. There's an SOP, I believe it's 4.1.1, and after their analysis that the actions were excessive, Officer Roth was fired. We have also concluded that Roth was aware that the taser in Brooks's possession, that it was fired twice. And once it's fired twice, it presented no danger to him or to any other persons. Now, we have had something quite remarkable to happen in the case, and it involves the testimony of the other officer, Devin Brosnan, because Officer Brosnan has now become a state's witness. He has decided to testify on behalf of the state in this case. What he has said to us, that is within a matter of days, he plans to make a statement regarding the culpability of Officer Roth, but he indicated that he is not psychologically willing to give that statement today. Officer Brosnan, however, has admitted that he was in fact standing on Mr. Brooks's body immediately after the shooting. So these are the charges that we have had filed today, signed by one of our Superior Court judges. These are the 11 charges against Officer Roth. The first charge is felony murder. This is the death that is as a result of a underlying felony, and in this case, the underlying felony is aggravated assault with a deadly weapon, and the possible sentences for a felony murder conviction would be life, life without parole, or the death penalty. Now, he's also charged in the arrest warrant with aggravated assault with a deadly weapon, and this is a count charging him for the shooting of Mr. Brooks, and the possible sentence for aggravated assault is 1 to 20 years. The third aggravated assault account is for the shooting towards or in the direction of Mr. Melvin Evans. Mr. Evans was the person who was seated in the car. Do we have the picture of Mr. Oh. And if you would point out, this automobile is the place that Mr. Evans and his two companions were driving, and a shot was fired. And I believe we've also got a photo of the shot that ended up in the vehicle. I think you gotta stand it up. And so with count 4, with the Williams, who was in the count 5 is an aggravated assault charge, and this was a charge for shooting towards or in the direction of Michael Perkins. Mr. Perkins was seated in the rear of this same vehicle at that time. There's a charge for criminal damage for shooting into that vehicle. Also, Officer Roth is charged with 7 violations of office. Each one of those carries a 1 to 5 sentence. These are violations of his oath of office for the city of Atlanta, arresting Mr. Brooks for the DUI without immediately informing him of the arrests, shooting a taser at Mr. Brooks while he was running away, which again is a violation of Atlanta's own SOP. Thirdly, excessive force when shooting a firearm at Mr. Brooks. And number 4 is the failure to render timely medical aid. Those are the 4 violations of oath. The 8th is for kicking Mr. Brooks, and the possible sentence for kicking Mr. Brooks is from 1 to 20 years. And we actually have a photograph of the And these are the charges for Officer Brosnan, and there are a total of 3 charges. And the first charge is for aggravated assault, and this is for standing or shoulder. The possible sentence for this crime is 1 to 20 years. And this is a photograph of Officer Brosnan, who you can see to the right. And at the time of the photograph, he is standing on the body of Mr. Brooks. Earlier in our conversations with Officer Brosnan, he has admitted that he stood on the body of Mr. Brooks. He said he believes that he was standing on Mr. Brooks's arm, but that is what the photograph shows. We've also charged him with additionally 2 violations of oath. One is for the standing on the shoulder. That is an unauthorized weaponless control technique which the city of Atlanta prohibits. And the second violation of oath was for the failure to render timely medical aid to Brooks. We are asking Officer Roth and Officer Brosnan to surrender themselves by 6 p.m. on tomorrow. Because Officer Brosnan is now becoming a cooperating witness for the state, we are asking the court to grant a bond of $50,000 and to allow Mr. Officer Brosnan to sign that bond. As I indicated, that he would become one of the first police officers to actually indicate that he is willing to testify against someone in his own department. As for Officer Roth, the person who fired the 2 bullets, we're recommending no bond for Officer Roth. If he is given a bond, that would be done by one of our Superior Court judges. But because of the severity of his act, and then following up that act with kicking Mr. Brooks, we're asking that he not be granted a bond. I think that's it. I do want to ask Mr. Sean Williams. Mr. Williams represents Melvin Evans, who was driving the vehicle from Memphis. I have already apologized to Mr. Evans on behalf of the people of Fulton County and the city of Atlanta. He was only down here for a short while, and it's really unfortunate that he was his.
Mr. Howard, first want to, on behalf of all 3 of my clients, not only witness this horrific and tragic killing of this young man, I want to offer the condolences from them to the Rayshard Brooks family, and particularly his daughter. It has been very difficult for each one of my clients because they witnessed it, and they themselves have a lot of emotion on what they saw and what they was a part of involuntarily. I want to thank Paul Howard personally and commend him. I've been doing these type of cases across this nation, and Mr. Howard is one of the few prosecutors who will actually go on the line to even investigate something like this, as serious as this, and to do it in a way that I believe makes this city proud, as I'm a resident of this great city. And as he said, with greatness comes responsibility. The city of Atlanta is a great city, and I wanted to apologize to my clients themselves that they came from Memphis and witnessed this. They're not going to give statements here today, but I will confirm to you that they presented today by Paul Howard. It confirms that at no time was Mr. Brooks ever a threat to anyone, including the officers in that Wendy's parking lot. My client's statements confirm that Mr. Brooks was running, his back was turned, and was never a threat to anybody. The only threat that arose is when officer pulled out a gun. Those bullets entered that bullet came very close to them, and Mr. Brooks's body laid less than 10 feet from their vehicle. And keep in mind, this was in a crowded Wendy's drive-through parking lot. And when you take the actions of reasonableness, as Mr. Howard said, reasonableness never has a deadly weapon being fired when you have innocent bystanders like my client standing. All of those things, as well as the fact that Mr. Brooks was not a threat to any officer that night, should have gone into play, but it didn't. And I hope and pray that with this action by Fulton County District Attorney's Office, as well as the actions by Mayor Bottoms and the task force, that we don't have to have any more press conferences like this anytime soon. Thank you, Mr. Howard. I appreciate it.
And ladies and gentlemen, Mrs. Miller, who is the wife of Rayshard Brooks, is here today. I think her attorney, Chris Stewart, is going to speak in her stead.
Good evening. I'm Chris Stewart with my law partner, Justin Miller. Tamika is not in a position to speak right now. She wasn't aware of all of this information, just like we weren't aware, just like I don't believe the nation was aware of all of this, that the shot happened after the deployment of the Taser, where he started running again, that you would kick another human being after you just put 2 bullets in his back. But even in dark times like this, you have to try and see the light. And the positivity of this situation is the courageousness of Officer Brosnan to step forward and say what happened was wrong. It is officers like that who change policing. And I know he'll probably catch all kind of problems and hate and things like that, but it's the courageousness of those type of officers that we love and support. It's the courageousness of district attorneys that are going to do their job. And we were willing to accept whatever the findings were. But that's why people elect you. Do your job. That's why you become right. So it's a day of joy watching the charges and what's going to happen to this officer, because it shouldn't happen. So it's heartbreaking, but it is an attempt to redefine justice. Because like I said before, we don't have any idea what it is anymore in this world. And if this is what justice is going to start looking like, officers stepping forward to stop other officers, coming forward and helping try and get a family who now has their father gone justice, then we support it. And thank everybody out there who is supporting this family and trying to change the world of policing for the better for everybody.
All right, I am going to try to take a few questions. I promised Ms. Miller that I would get a chance to spend a little time with her before they had to leave. It is a very unfortunate situation for her, and so I'll take a few questions at this time.
Mr. Howard, could you elaborate, please, on this being the first time a law enforcement officer here in Atlanta has decided to come forward and say they will indeed speak against a partner in the department, sir?
We have of these cases that we've prosecuted, and I don't remember a circumstance where we've had an officer, particularly in a case this important, to step forward and to say that they would cooperate with the state. So we are really appreciative of Officer Brosnan. Hopefully that will mean that this matter can be resolved in a much quicker manner, but we certainly appreciate his courage in standing up and taking that step.
Mr. Howard, at what point did he come forward? Say you're in a fight for re-election, to see the speed of this decision being much quicker than previous cases and possibly a
the wrestling took place on the ground, you could tell he became a lot more emotional, and that's when he said to us that he needed some additional time to explain to us his feelings about the shooting that took place immediately afterwards. He did tell us that he approached the body afterwards, and he admitted that he did, in fact, as he described it, stand on the arm of Mr. Brooks. We asked why did he stand on his arm, and he said something to the effect that he really didn't know what was going on, and he was trying to ensure that Mr. Brooks did not have a weapon. And we found that kind of strange because Mr. Brooks had already displayed to them the fact that he did not have a weapon.
To piggyback on what Joe said, there are other use of force cases in your office right now. What can you say to the families who are looking for closure too? If they see this and they're like, this is getting all the attention, what can you say to those families?
Well, this is what I would say. We have been working diligently to prepare those cases, but this case has something that many of the others don't have. Number one, we've got videotape. We don't have body cams, we don't have dash cams, and so we have spent an inordinate amount of time and large sums of money trying to recreate crime scenes. We're not allowed, the police officers will not give us statements, and that's why we're very surprised, and really almost shocked that Brosnan has come forward, because in our other cases, we do not get statements to assist us from the officers involved. One of the things that I'm hoping that we will pass, not only in our state, but in the entire country, is that I think we need to change the law. I believe that prosecutors should be allowed to indict cases directly without a grand jury when they involve police shootings. And the question that you asked me, I would say to those folks that are waiting, if I had the authority to sign the indictments, I would sign them today. And I'm hoping, our legislature is in session. If you really want to do something to improve police misconduct, why don't you give district attorneys the right to proceed with the case without waiting for a grand jury? And that's particularly important now during the virus, is because it looks like right now we won't convene a grand jury in Fulton County until October. That's a long time. I wish that we could do it today. We sometimes we do and sometimes we don't. Well, we didn't need it because as we pointed out, the evidence was available. We could move forward without getting the reports from the GBI. And we've been working with the GBI. In fact, today we worked together with the automobile that we talked about. So it was a different circumstance, because once you get the videotape, and we've had 8 of them, I believe, in this case, it places the case on a different level of being investigated.
Mr. Howard, you said he was not a threat to the officers. Is it the fact that he was running away, is that the key evidence there leading you to that decision that after the struggle he was not a threat to the officers?
Well, that's just one of the things. I mean, as we said before, the whole casual conversation, the fact that they patted him down, he had no weapon, even the body language between the officers and Mr. Brooks, it was very casual, very informal. Nothing seemed to happen that would indicate that he was of some danger. But you're right, at the critical point of the shooting, what the evidence shows that he was some 18 feet, 3 inches away. His back was turned, and I believe a reasonable person would conclude that he was not an immediate threat at that time.
Mr.
Yes, sir.
What do you feel about your warrant and your indictment versus qualified immunity? Do you think the qualified immunity should be changed?
Well, I have put together a list of 9 recommendations, and I believe recommendation number 8 is that we ought to eliminate both sovereign immunity and qualified immunity for cases involving police shootings. We've got to do it. And, you know, my barometer that says to me that something is wrong with that immunity, even our good friend Clarence Thomas says something is wrong with it. And when Clarence Thomas says that it's bad, you know it's probably pretty bad. And so I think we need to change it. We need to change it so that the families of victims, like Mrs. Miller, the way that the law stands right now, they don't stand a very good chance if they decided to pursue some lawsuit. It ought to change for people all over the country.
Mr. Howard, how would you characterize the work done by your team and what happens next? What has to go in?
The way that the law stands now, we'll wait for an indictment and already scheduled 7 cases that are scheduled to be presented to grand juries before this one. So I would suspect that we're probably talking about January or February when we would get a chance to present it to a grand jury. I believe that should be eliminated. I don't think we should wait because the district attorney, or why can't the district attorney just sign the indictment and let the case go forward?
Mr. Howard, while you recommend no bond for the officer, what's the likelihood that a Superior Court judge will give him a bond? If so, what do you think the bond would be?
I have long given up predicting Superior Court judges. I do not know.
So since Atlanta has the only police oversight agency in the state, what do you feel about statewide police agencies throughout the state to help the citizens?
Well, as I mentioned, the list of the 9 things that I'm recommending, one of the things that I think we ought to do for the whole country, if there are 18,000 police departments in the United States, every one of them ought to have a civil citizen review board. But I think the citizen review board ought to be changed to require that when the city does not follow the recommendation of the review board, that failure to follow it ought to be signed off by the mayor, it ought to be signed off by the police chief, and with your board, will be proven to be the correct view of what happened. Thank you all very much.